So, you know that man that was coming after the Fearless Fund, the fund ran by Black women that was helping other startups? Well, they have a bigger plan. They were just targeting these women first. So, this article is out of Fortune. It's titled DEI Opponents Are Using Civil Rights Act Section to Go After Venture Capitalist Fund That Invest in Businesses Owned by Women of Color. It's a very clever game plan. Let's look at what they're talking about. This literally just got released. Guys, I am less than 5,000 subscribers away from having 40,000 subs. Can you go ahead and smash that like button for me? Thanks. Okay, bye. Opponents of workplace diversity programs are increasingly banking on a section of the Civil Rights Act of 1866 to challenge equity policies as well as funding for minority-owned businesses. Section 1981 of the Act was originally meant to protect formerly enslaved people, or Black people specifically, from economic exclusion. But now, the American Alliance for Equal Rights, a group run by Edward Blum, the conservative activist who challenged affirmative action in higher education and won, is citing the section to go after a venture capital fund called the Fearless Fund, which invests in businesses owned by women of color. A federal appeals court temporarily blocked funding for the Fearless Fund's grant program as the case proceeds. Conservative activists have brought lawsuits using 1981 section against other companies and institutions, including insurance company Progressive and pharmaceutical giant Pfizer. The cases are being monitored carefully as the battle over racial considerations shift to the workplace following the U.S. Supreme Court's June ruling ending affirmative action in college admissions. While the 1981 statute has been used well before the latest affirmative action ruling to prove reverse discrimination, Alfonso David, Fearless Fund's legal counsel, who serves as president and CEO of the Global Black Economic Forum, said that there is a coordinated use of Section 1981 now that we did not see before. Okay, what is it? The 1866 Civil Rights Act is a federal law prohibiting discrimination on the basis of race, color, and ethnicity when making and enforcing contracts. The Section 1981 specifically grants all individuals within the U.S. jurisdiction the same rights and benefits as enjoyed by white citizens regarding contractual relationships. However, the Supreme Court's 1976 McDonnell versus Santa Fe Trail Transportation decision broadened those protections, ruling Section 1981 prohibits racial discrimination in private employment against white people as well as people of color. It's a very clever game plan, said Randolph McLaughlin, a civil rights attorney and law professor at Pace University, referring to the use of the 1866 law. They want to turn civil rights law upside down. The standard approved for the 1981 section is high. That's because of the Supreme Court's 2020 decision in Comcast versus National Association of African American Owned Media, establishing that the plaintiff who sues for racial discrimination under the section bears the burden of showing that race was the central cause in denying a contract opportunity, as opposed to merely a motivating factor. Why not rely on Title IX instead? Title IX of the 1964 Civil Rights Act protects employees and job applicants from employment discrimination based on race, color, religion, sex, and national origin. If the plaintiff opts to sue via Title IX, then he or she needs to file a charge with the EEOC. That's a process that takes up to 180 days. After that, the plaintiff can file a lawsuit. Choosing the 1981 route is much quicker. Section 1981 is also broader than Title IX, which generally applies to employers who have 15 or more employees, legal experts said. Also, under Title IX, a plaintiff can recoup only up to $300,000 in compensatory and punitive damages total. Section 1981 has no limitation. Title IX does have a lower standard of proof than Section 1981. Plaintiffs only have to show race was a motivating factor, not a central cause. Why is the case against the Fearless Funds potentially significant? In its lawsuit, American Alliance for Equal Rights seeks relief by arguing that the fund's Fearless Strivers Grant contest, which awards $20,000 to Black women who run businesses, violates Section 1981 by excluding some people from the program because of their race. So we shall see how this goes down. So what do you think about this one? How do you think this case will play out? They are really coming for these DEI initiatives in many different ways. One more article that came out just yesterday, Bill Ackman just fixing things with moves against university leaders and diversity programs. That's what I do. They are coming hard for these diversity programs. Bill Ackman wants you to know this. He's just getting started, and he doesn't care that he's making adversaries in the media or on the political left. His months of haranguing Harvard University President Claudine Gay ended in her resignation. Now the billionaire hedge fund manager said he intends to use his money and influence wherever he chooses. Item number 1, higher education. Item number 2, the media. Item number 3, free speech. Items number 4, 5, and 6, stay tuned. That's what I do. I fix things. Ackman said in an interview on Wednesday, this is just fixing things. They are so tired of us colored folks just showing up everywhere. They are really trying to fix things. Ackman, 57, has opined on thorny topics big and small for years, but in railing against anti-Semitism on campus and the way diversity programs are run has touched a nerve. His persistent campaign against Gay, the first Black president in Harvard's 387-year history, has prompted the ire of critics such as Reverend Al Sharpton, as Ackman widened the scope of his invective from academia to the media. In the past week, lampooning and more criticism followed. The Financial Times offered a quiz inviting readers to guess the source of several quotes, Bill Ackman or American Psycho. Lord. But Ackman has also won praise from conservative activists, members of the Jewish community, and even Elon Musk. That's emboldened him to push ahead with the same pugnacity that defined his Wall Street career. And for anybody that doesn't know the definition of pugnacity, which I did not, that means the quality of wanting to start an argument or fight, or of expressing an argument or opinion very forcefully. His pugnacity and controversial business dealings had made him unpopular. See pugnacious. There, you learned a new word today. For now, details around the next stage of his plan are still coming into focus. On Friday, Ackman told CNBC it will be akin to a think tank, but more of a think and do tank. So, and the rest of this article is just fluff. It's just kind of giving more background on this man. So I am not going to go into all of that. If you want to see the rest of the article, this is also on Fortune. I am just highlighting that these people are coming. They have a game plan. They have a to-do list on who they are coming for. And they are coming for the folks that they believe are unrightfully taking folks' spots because they have an idea on who is supposed to be in these spots. So these diversity, equity, and inclusion initiatives, if y'all have these initiatives in your employer, y'all should just literally strip the title and just keep doing the work. All right, what do you guys think? Go ahead, jump in the comments, let me know, like, comment,